We'll hear argument this morning in 2424, in re the estate of Johnson from Kaufman County and the Fifth Court of Appeals District.
May it please the court, Ms. Hollingsworth will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. Can you hear me?
We can, Ms. Hollingsworth.
Okay, I'm sorry, a little technical problem here. May it please the court. Good morning, Chief Justice Heck and other members of the Texas Supreme Court. We're grateful to have the opportunity to present argument, and we appreciate the court's time. This is a will contest. Tia McNerlin, who is the respondent in this court, accepted part of what she was devised under a will. Several months later, she brought a will contest. Lisa, the petitioner in this case, and the executor of the estate of Dempsey Johnson, moved to dismiss her lawsuit for lack of standing. Generally, to maintain any lawsuit, it's necessary for a person to have standing to litigate the matters in issue based on an interest peculiar to the person individually and not as a member of the general public. The estates code places a heavier burden on the would-be litigant in probate matters by requiring that the party as an interested person is defined under the estates code. A person is interested if she is a devisee or a creditor or an heir having a property right in the estate being administered. It's undisputed that Tia is a devisee under the will, entitled to receive the mutual fund, as well as other benefits under the will, including the proceeds from a bank account, interest in real property, and a third of the residual estate. As a threshold matter, the contestant of the will bears the burden of proving her standing at a hearing before the trial of the merits. Because only a person interested in the estate has standing to contest the will, then a person is stopped to contest the will due to acceptance of benefits thereunder and does not qualify as an interested person. A person cannot take any beneficial interest under a will and at the same time claim any interest which would defeat or in any way prevent the full effect and operation of every part of the will.
So, Ms. Hollingsworth, would that mean that if there was an estate that was worth, say, $10 million and there were two siblings and one sibling was specifically bequeathed a car, for example, and for whatever reason needed that car and so took that car for whatever purpose, that then that person would be denied standing to go forward with the rest of the will of the estate?
Yes, Your Honor. And what you're alluding to, I believe, is generally what comes up in divorce cases where there's undue duress in accepting part of the benefit. But under the law of election and estoppel, because there are in your situation, there were two siblings. And only those two were involved. The question is whether a person accepted something which she could have been deprived of absent the will. And so because the car was not, I think you said it was a him, he needed it for transportation, but it wasn't his car before. A person cannot accept anything under the will and then have the right to come contest the will. The reason why.
So you're saying, yes, if the person took that car to go take care of whatever, that therefore that person would be denied standing to contest whatever.
Yes, because the public policy is you can't treat a will as both void and invalid. And a will contest is an attempt to state that the will is void. But
Ms. Hollingsworth, What about the entitlement exception? It seems like under the scenario here, the benefit would have accrued regardless of whether there was a will or not.
No, Your Honor, that's not the case. This was not a payable on death situation. It was something that Tia was only allowed to receive as a devise under the estate. It was part of the estate property. And children or relatives or whatever are not entitled to receive anything when a person dies unless there's no will. And then there's the statutes of descent and distribution.
If this will is invalid, would there be any valid will? And then wouldn't you just resort to the probate code?
Well, there's no evidence of what the terms of the other will was, whether it would be valid too. There could be 5 other wills back there that you would have to go through to get to the analysis that the Court of Appeals did. But mainly there's no evidence of any of that in the court record, which is a problem with this whole case and even discussing it, because the only evidence before the trial court was a judicial admission by Respondent, Tia, that she had accepted the benefit. And our position is once that was established, which was judicially admitted, the inquiry should have ended there. Tia doesn't dispute that she accepted the benefits. What she disputes is she thinks she was entitled to more if he had died intestate, and therefore she wants to contest the will and see if she can get more. There aren't any appellate cases, and certainly not from this court, dealing with the burden of proof. But what Tia is in a will contest, there are, as you will know, in family law cases, such as there are numerous, this comes up a lot in divorce cases, and there are numerous cases where a spouse has tried to prove that he or she was entitled to an exception of estoppel because she was under economic duress or for some reason like that. This court didn't address it in Kramer versus Castleman, but the Court of Appeals in Castleman versus Castleman noted that once an appellee establishes the acceptance of the benefits, the burden shifts to the appellant. And that would be, in other words, once Lisa established that Tia had accepted benefits, the burden shifted back to her to show either that the doctrine didn't apply or that an exception to the doctrine existed, such as in Castleman, which was it was involuntary acceptance. It was their argument due to financial reasons. Equitable policy decisions are different in determining whether an appellant has waived a right to appeal, where both the appellee and the appellant, they were the two owners of the property before divorce, and even after perhaps a settlement. But in a will contest, whether a contestant has elected to destroy her standing to contest a previously probated will, where none of the parties had any interest in the devised property until death, the public policy considerations are different. There are numbers, and in any case, there could be many other beneficiaries to whom the estate's been distributed. And the acceptance of the benefit goes into the whole estate planning scheme. But also, back to the comparison with the family law cases, Tia didn't have any right to any of this unless her father devised it in his will.
Or unless he died intestate, right? I mean, then she would have rights. I guess that's where I'm troubled. Because let's assume there aren't other wills out there. There aren't 5 other ones.
Okay, we can assume that, but there's not any evidence that he would die intestate. There's not any evidence of how many heirs he had. We dispute that at one point, Respondent says there were the 3 sole heirs. We agree there were 3 daughters, but there's no evidence that they were the only heirs. There's no evidence how the property would be divided. There's no evidence there's no evidence for the Court of Appeals to engage in presumptions contrary to the judgment to supply the evidence that Dempsey would have died intestate, that even if he did, how the property would be divided. The Court of Appeals should have engaged in presumptions in support of the judgment. Neither party asked for findings of fact and conclusions of law. And therefore, any findings that need to be made would be presumed in support of the judgment. And furthermore, it's the general rule that presumptions are in support of the judgment. The Court of Appeals just did the opposite. The Court of Appeals took judicial notice. Yes, Your Honor. Did you have a question, Judge Bland?
So I think the evidence that the respondent points to is the inventory that was filed by your client that has total assets of about 1.4 million, excluding the mutual fund account. And I think the argument is that the mutual fund account is less than a third of the overall estate. And so there's a mathematical calculation that a trial judge should undertake in determining whether there's been knowing acceptance of benefits. And it's got to be this calculation of, have you accepted more than you were otherwise entitled to? So where is that analysis, just not correct?
Well, first of all, there's no evidence that only 3 people would have divided that estate. And inventory and appraisement is not evidence of the fact the court wasn't asked to take judicial notice, the trial court could have taken judicial notice of the fact that an inventory was filed, but couldn't legally take judicial notice that that was the value of the estate. There are numerous cases that are cited in our brief, but basically a trial court can take judicial notice of pleadings filed in the case in some circumstances, but only if the trial court's asked to. Documents attached to pleadings are not evidence unless they're introduced into evidence. And there are a number of cases that deal specifically with inventory. The court can, if asked, which the trial court was not asked, take judicial notice that an inventory was filed, but the court can't take judicial notice of the contents therein. Now, I don't know if that answered all your question or not. The Court of Appeals, in its opinion, stated that we assume the trial court took judicial notice of the will and its contents as well as the inventory, which was in the trial court's file. And then the court also stated, because opposing counsel had filed a motion for the court to take judicial notice, in its order, it says, we presume the trial court took judicial notice of the matters requested in this motion. We have no need to judicially notice because it came to us in the record. Well, that's really bad precedent. That stands for the proposition that you can put anything in you want to in the clerk's record, and that the Court of Appeals will rely on it, even though it was never admitted to the trial court. The trial court wasn't, even asked to consider that. So there are a number of things wrong, but with this case, but where it really, what's really wrong with the case is there was no evidence offered that the trial court considered. The trial court took judicial notice of something that the Court of Appeals did not consider, and the Court of Appeals was never asked to consider. Now, I have the greatest respect for opposing counsel, but after he received my appellee's brief in the Court of Appeals, it was like, oh my gosh, well, I'm going to ask the court to take judicial notice of this stuff that was attached to the pleadings. Unfortunately, the Court of Appeals presumed the trial court had taken notice of it, which was contrary to the judgment, and said, well, we don't even have to take judicial notice In addition to the merits, the procedural errors in this case, I think certainly suggest that the case should be reversed and the trial court judgment reinstated.
Any other questions?
That's anybody here?
Thank you, Ms. Hollingsworth.
Thank you, Your Honor.
We'll hear from the respondent.
May it please the court, Mr. Monning will present argument for respondent.
Please, the court, I think in this case, the court is asked to decide whether Texas prefers a policy that enables a will contestant to proceed with their contest on the merits and reaches what's called a merits-based decision, or whether it wants to allow a nervous executor to set a trap for a possible contestant by making an early partial distribution and then saying that if the distribution is accepted, that they are forever thereafter barred from contesting it. Texas, but to get to that issue, the question been raised is whether there's an evidentiary record that supports it. In reverse order, the policy that they're asking the court to adopt of strict forfeiture by acceptance of any benefit under the will is not mandated by Texas law. The only time this court has addressed it was in 1978 in the Turcotte v. Trevino, which said that there will be a bar if only if it would otherwise, the distribution only otherwise interfere with complete implementation of the will. This one did not.
Mr. Monning, but that point does raise the issue of what type of evidence should be before the trial court to determine whether or not the devotee or the interested person that accepted the benefits would have otherwise been entitled to benefits. And whose burden is that? Because here Tia says, admits she accepted the benefits, but why shouldn't she have the burden to say, look, I would have gotten this no matter, whether there was 5 wills or 1 will or no will?
I can't deal with the argument about there being 5 wills because I'm not aware of but 1 will, and the record has only 1 will and therefore 2 options, this will or intestacy. Now, as far as whether Tia has the burden, I don't know that there's a case that lays out the order in which the burden would shift, but you would normally think, well, I operate generally intuitively under the presumption that the burden follows what I'll call the risk of non-persuasion. The first issue that comes up is, are we an heir? Is Tia an heir? Well, there's a question been raised whether she was or not, but the decedent, the testator himself, said she was an heir in the will. He says, I have 3 children, Tia, Lisa, and Carla. That was before the court. And in fact,
was there some evidence of a brother or some discussion of a brother?
There is something in the record, but Your Honor, I don't know anything about that. I was not involved at the trial stage. I think there may have been a deceased brother.
With children. And I think you can assume there were children because that would be the worst case. But so assuming that we're looking at this as the will versus intestacy, and would your client be able to take the entire proceeds from the mutual fund account solely in her name under the law of intestacy?
She would not be able to
would
take.
She have to share that with the other heirs as opposed to the specific bequest in this will that awarded the account in total to her?
I believe she would not have been able to take that account in kind. I think the law is pretty clear that upon a decedent's death, the property vests in the heirs or the devotees, quote, subject to the administration of the estate. So I believe probably that had he died intestate, that each would have received their pro rata share of this account plus the others. But this was a stock account, so it's fully fungible and easily if it was, well.
But
easily-
it didn't have anything like a right that she maintained outside the will, like, for example, payable to her upon
This
her
was not a
father's
payable on
death,
death
or
account.
passed under an IRA that had another beneficiary, or some other legal basis for her to claim the account.
None.
Okay.
Her entitlement to that specific account came under the will. So I contend that she had the burden to prove that she had standing. Now, there are cases in which they talk about this acceptance of a partial benefit as denying standing. I don't know if that's really a true standing issue, if that's just the way that those cases were the language used when those cases were decided. But clearly, Tia was an heir. She had statutory standing to bring a will contest under a provision of the State's Code 55018 or something like that. So she had what I'll call prima facie standing. Then the question becomes, did she receive a partial distribution? Well, she admitted she did. She said so in a pleading that was filed. I believe that would be incumbent on Ms. Hollingsworth's client to prove that. But I think it was if it wasn't judicially admitted, it was certainly there was an admission of a party on file. Then the question is there an exception to that rule of that would take us outside it, which would say under the Trevino versus Turcotte case, whose burden is it to prove that the distribution to us would not otherwise interfere with full implementation of the will? I believe that was probably our burden to prove, but likewise, we did prove that. The will on its face says we were entitled to that asset. Furthermore, under the will on its face says we were entitled to more than that. There is a $200,000 plus stock account, and there was at least one tractor lot of real property that was part of the residual estate. So we were due more than that under the will, and we were due more than 3 times that under the laws of intestacy. And they're saying this whole thing about, can you take judicial notice, or do you have to request judicial notice, or do you have to mark exhibits? That becomes a problem for them before it becomes a problem for us, because we have prima facie standing because we were the daughter of the decedent. They then have got to do something to prove that we received a partial benefit. They didn't ask that any documents be offered in evidence or take judicial notice of anything. It was taken as true. They did exactly the same thing that Ms. McNerlin's counsel did below. They filed pleadings, they attached exhibits to some, and they argued those propositions to the trial court. And each of those propositions was raised to the trial court. Who were the heirs? What about the partial distribution? And what was the size of the estate? That's there is a reporter's record, but all it was a transcript of the arguments that were made. So that's a long response, but the bottom line is, I believe it probably should be our burden to show that the distribution we received would not interfere with full implementation of the will, but it was done. And in this case, it almost makes no difference who had the burden, because all of those facts are established. The rule of evidence that says you've got to be with reasonable certainty according to evidence that's readily available, and it certainly was readily available what was in the pleadings and what was sworn to.
Counsel, if the will contest were successful, that would that invalidate the receipt of property that had already taken place under the will, and would then that property have to be paid back so that it can all be sorted out under intestacy principles? Or, I mean, how would that work?
Well, I think that's how it would. I think it would be under, you're in court, so you've got the ability for judicial oversight of how the reckoning is to be done. But yes, if she received 100% of one asset and she's only entitled to 1/3 of it, then she would have to account to the others for that. As it happens in this estate, and you can take judicial notice of the will, Lisa received the bulk of the estate. So it's easy to make Lisa whole for her 1/3 share of this account if this account were not distributed. But the answer to your question is yes. I think you would have to have some kind of a reckoning or just under principles of accounting, I suppose. The other thing that the Trevino versus Turcotte, there's argument that it bars the acceptance of any benefit, just bars a will contest, and Ms. Hollingsworth has plainly said that's what her position is, but that ignores the other language that says it's got to be interfere with the operation of the will, and I fail to see how the acceptance of this early partial distribution interfered with anything else that the executor had to do.
Your Monty, does it have to interfere with the operation of the will, or would the question be, does it interfere with the operation of what would happen if this will contest were successful? So in other words, is accepting the benefits inconsistent with what she would get, what your client would get if the will contest was successful? Isn't that the question we should be asking?
I think if you follow the Trevino versus Turcotte or language, it says it would interfere with, I believe it's full implementation of the will. But if rather than but I think it's still going to have to be, if your question is, if the will contest were successful and there was an intestacy situation, would she have to account? Well, yes, she would. Is that addressing your? Yeah.
Yes,
Well, I still have a question there. But if the will contest is successful, then it defeats all of the will almost, doesn't it?
Yes, it does defeat the will. And he's intestate under the record here. In which case,
so you can't retain an interest and also a claim that if the claim were well founded, it would defeat the will. It would defeat the will.
Well, it would. Yeah, maybe I misunderstood Justice Busby's question then. I do not contend that a successful will contest would have left the will in place.
Well, and the tension there, of course, is that her position is that money that she's taken that's in her bank account is not hers. And she's not paying it back. She's not paying it back to the court to be dispersed later. She's holding on to the money and then taking the position in court that it's actually not mine because the will is invalid. I mean, that's the equitable conundrum that gives rise to the sort of bright line rule.
Well, she may be saying it's not mine as a matter of strict, maybe title, to use that word, but equitably, she's gonna get that much and more if she's successful. So what is the detriment to the estate of her having received this partial distribution? These ideas of barring a marriage-based disposition. I know Kramer dealt with a divorce context, but there were several factors involved, and many of them relate to whether or not there was prejudice to the opposing party. And in this case, it's almost impossible that there be prejudice to Lisa Joe because she received most of the assets, number one, and if she has done something to remove those beyond the court's access, then she would have a bigger accounting job to do than would Tia. To me, the Kramer versus Castleman case applies. I mean, it was a divorce context. Ms. Hollingsworth has not joined issue with me on whether or not that preference for a marriage-based decision is applicable. Clearly, it applies outside the divorce context. There were cases relied on that were motion for new trial cases. One of the cases that was relied on was the Lopez versus Hakama, the case in which the contingent fee was increased by 5% if there was an appeal, and the lawyer distributed all of the fee to the clients except the 5% that and there was a controversy over whether the 5% had been earned, and the court said that the client's acceptance of all but that 5% was not a bar to the clients bringing that action against the lawyer to try to recoup the 5%. So it's the merits-based outcome is not only expressly preferred by the court. I think it's inculcated into the culture of the state practice. You look at all of the cases that have dealt with this issue in intermediate courts. You've got the McDaniel case out of Texarkana that expressly went contrary to us, but all the other cases that dealt with it inferentially allowed a merits-based outcome to proceed. Sometimes the basis was seemed technical, but at the bottom line was the courts intuitively allowed a merits-based outcome to proceed. And I think that's that's a reflection of the legal culture in the state. I've really said about what I feel I need to say to make my points clear. On the evidence, again, I cannot emphasize more all of the lack of magic words, please take judicial notice or mark this as an exhibit. That is an equal problem for both sides. And the others, they have got to prove the partial distribution, or we're in court. So I appreciate the court's time, and I cede the rest of my time to the court.
Any other questions? Thank you, Mr. Monning. Ms. Hollingsworth, I think you have 5 minutes.
I think it's important for the court to remember the posture that we're in, and that is there was no evidence before the trial court. There was no evidence whatsoever that Dempsey Johnson would have died intestate. So while these questions might be interesting in another context, they're not in this case. To the extent the court looks at the will, which, by the way, the will was not admitted into evidence. What was conceded was that Tia was a devotee, not an heir, was a devotee under the will, and that she had accepted the benefits. But if the court looks at it, there's an indication reflecting prior wills. So we can't deal with just the assumption, which is not based on fact, that he would have died intestate. Texas law presumes that people die testate and they can dispose of their property however they want to. There's no evidence that there were only 3 people who would share in the division of the estate. There's no evidence whatsoever. Tia treats her election to take the mutual fund and the other bequests that she hasn't gotten yet as if she was keeping something that was already hers. But that's not true. Throughout her briefing, Tia makes statements such as the mutual funds was much less than she was entitled to under intestacy, much less than she was due, that she was entitled more. Tia wasn't entitled to anything. The fact that she might have had Dempsey died intestate, been entitled to a percentage under the descent and distribution statutes doesn't take away from the fact that Dempsey had a right to leave a will disposing of his property however he wanted to.
Ms. Hollingsworth, at its core, wasn't it your client's burden to prove that because of this partial distribution, if she was successful in her claim, that you would not be able to even it out in accordance with the testator's intent? Wasn't that your client's burden?
No, it was not our client's burden. First of all, there's not any evidence of that. It was the executors, as a proponent of the will, it was her burden to show that the would-be contestant had accepted benefits under the will. And general policy of the state, whether it's a contract, whether it's a will, you can't treat it as both valid and invalid. This was established through Tia's judicial admission. That if in order to have an exception, the burden shifted to Tia, the will contest. It would be bad precedent, I think, Your Honor, to have that burden as you suggest, because then in any type, somebody could come in and take what they were devised under the will, as long as they filed it within 2 years, file a contest, and regardless how many devisees there were, how much cash had been distributed, what happened, the whole estate would have to be unwound. And as we were discussing earlier, this is more than just a husband and wife. There are, lots of people involved, and it's a public policy argument that you can't have it both ways. Tia's trying to treat the will as valid and void, and the law doesn't allow that. Most of the facts that Mr. Monning was arguing are not facts that were before the trial court, and therefore could not have supported the trial court's judgment and could not have supported the Court of Appeals judgment. Basically, this is just a no evidence case. The fact that Lisa received the bulk of the estate, that's nowhere in the evidence. The fact that her taking of a mutual benefit, how in the world can we speculate that it wouldn't interfere with the operation of the will? That's not, Lisa doesn't have to come in and prove that, the executor doesn't have to come in and prove that because Tia took that, it's less than she would have gotten under will number 1, will number 2, will number 3, intestacy. That would be a really bad precedent to, after a will has, once it's been probated, admitted to probate, it's been determined valid. And so in the underlying will contest, Tia will have, that will be her burden. But before she gets to drag this back into court, she has to show that she has standing, and she didn't establish that.
Any other questions? Thank you, Ms. Hollingsworth. The case is submitted, and the clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.